Welcome to the Deep Dive, where we take a stack of sources and distill the most important knowledge for you. Today, we're embarking on a really crucial journey into the world of alternative dispute resolution. You'll hear us call it ADR, specifically looking at its vibrant and increasingly vital role within Ugandan legal practice. Our mission today is to give you a really comprehensive understanding what ADR actually is, why it's so significant right now, and how it's truly, transforming the way disputes are handled on the ground in Uganda. Now, you might be thinking, ADR, Ugandan law. Is this really for me? Well, let me tell you, understanding dispute resolution, it really goes far beyond the courtroom walls. It offers these invaluable insights into managing conflict, fostering efficiency, and achieving positive outcomes in nearly every area of life. Think complex business deals, sensitive family disagreements, even, those community squabbles. It's fundamentally about finding better, maybe smarter ways to navigate conflict rather than just sort of battling it out endlessly. Imagine this scenario. Maybe two long-standing business partners in Kampala, they're locked in a disagreement over a new product launch, their relationship. It's valuable, but the stakes are high. So do they go to court, risking public exposure, a potentially irreversible rift? Or is there another way? This is exactly the kind of real-world challenge that ADR is designed to step in and address. Okay, let's unpack this. What exactly is ADR, and why is it making such an impact in Uganda today?
That's an excellent way to frame it, a really practical way. And for this deep dive, our primary source is essentially an abridged introduction to ADR practice. It provides a really solid practical foundation for our exploration today. It's a document that's, well, designed to equip practitioners, legal professionals, but honestly, it offers such clear insights for anyone wanting to understand how modern legal systems adapt to the inherent challenges of conflict. We'll be connecting these foundational concepts to the specific evolving landscape in Uganda, offering, I hope, a truly insightful look.
Great. So let's start right at the very beginning then. When we talk about alternative dispute resolution, what are we actually defining here? What makes it an alternative? I think many of our listeners might have a general idea, perhaps, but let's sharpen that focus, especially within the legal context.
Right, so in Uganda, much like in many jurisdictions worldwide, the pathways for resolving disputes, they generally fall into two broad categories. The first, the one most people picture, is litigation. That's the traditional court process, formal, public, adversarial often. The second, and that's our focus today, is alternative dispute resolution, ADR. Now, what's often overlooked, but critically important, is that a dispute is fundamentally owned, you could say, by the litigant or the parties involved. It's their conflict. This means an individual, or say, a company grappling with a legal disagreement, has a fundamental choice to make. Do they want a judge to render a binding verdict, a decision imposed from outside, or do they seek resolution through a mediator, perhaps an arbitrator, or maybe even directly between themselves? So at its core, ADR describes this whole range of processes, these mechanisms, designed to resolve cases without recourse to the full formal court process, or often even before a case ever sees the inside of a courtroom. The alternative aspect, it just highlights its departure from that conventional, often adversarial judicial route. Think of the well-known examples like arbitration and mediation. Mediation, for instance, is remarkably flexible. It can happen before a lawsuit is even filed, giving parties a chance to settle privately. Or it can be integrated into the court system after a case has been filed. We call that court-annexed mediation. All right. The underlying principle, the common thread, is that the parties are actively pursuing a non-court-based solution. They're aiming for an outcome that doesn't necessarily involve a judge imposing a decision in a very public forum. It's really about empowering the parties themselves to find their own solutions, often guided by a neutral third party, rather than having a solution dictated to them.
That distinction is so important, isn't it? The judge dictating versus parties finding their own way. It sounds less like it's trying to replace the traditional court system entirely, maybe more about offering a robust complementary set of tools. It's like instead of everyone being forced onto a single, often incredibly congested highway, the court system, ADR, opens up multiple other routes, maybe more efficient bypasses, detours, potentially getting everyone to their destination faster and, with less wear and tear on everyone involved. Okay, let's bring this specifically to Uganda now. What's the current status, the historical context of ADR in the country? Has it always been a prominent feature, or is this more of a relatively new development that's taking shape?
Well, it's definitely an evolving landscape, yes. And to really understand its current trajectory, its momentum, we do need to glance back at its history a bit. There's a pretty stark observation from Honorable Justice Jeffrey W.M. Kiriyabwire back in 2016 that provides a good starting point.
Yeah.
He noted quite pointedly that ADR received minimal study time in law schools, that it struggled to gain traction within the courts themselves, and that very few law firms actually specialized in it. So this points to a historical lag, you could say, where the formal court system, which was established way back in 1902 during the colonial era, had long remained the predominant, almost the default mode of dispute settlement. Adjudication going before a judge that was the familiar pathway for generations of legal practitioners and the public alike.
Right, the default setting.
Exactly. But this historical context, this backdrop, actually makes the recent developments even more striking, even more significant. There's been a very clear, quite intentional shift towards integrating ADR more deeply. The Ugandan judiciary, for example, has significantly increased its use of ADR mechanisms. That's a major institutional move. Court annex mediation, that's mediation sessions facilitated directly through the court system, is now become an integral part of dispute resolution in civil matters.
So it's not just encouraged, it's built in.
It's increasingly built in, yes. This isn't just some minor procedural tweak. It's a systemic integration. And to support this, the judiciary has invested quite heavily in training and accrediting advocates and judicial officers. Not just within the formal justice, law, and order sector, which we often abbreviate as JLOS, but also extending this training into local communities, really trying to build capacity at the grassroots level. And this initiative, it's even garnered substantial international support. Partners like the Austrian government and Pepperdine University in the United States have backed this training, which really underscores a global recognition of ADR's transformative potential.
That international buy-in is significant.
It is. And beyond the official judicial channels, there have also been crucial local initiatives driving this forward. In 2018, for instance, the Uganda Law Society, in a really landmark collaboration with the Uganda Bankers Association, established the International Center for Arbitration and Mediation in Kampala. You'll hear it called ICAMAC. This provided a dedicated institutional framework, a modern hub specifically for arbitration and mediation practice. Now, it's important to note that before ICAMAC, another institution, the Center for Arbitration and Dispute Resolution, or CADR, already existed. It was established back in 2000 under the Arbitration and Conciliation Act. So while CADR laid some essential groundwork, ICAMAC really represented a new wave of institutional support, particularly aimed at enhancing Uganda's appeal as a hub for, international commercial dispute resolution. This whole picture signifies a really determined effort to not just implement ADR, but to institutionalize it, professionalize it, and elevate its practice.
It's truly fascinating, isn't it, how despite that long-standing tradition, that default setting of court-based adjudication, Uganda has pivoted so deliberately, so strategically. This feels like it's about more than just reducing caseloads in the courts, though I'm sure that's a factor. It sounds like a fundamental rethinking of how justice is delivered. So what do these developments, this training, these new institutions like ICAMIC, the mandatory court annex mediation, what does it all signify for the future of legal practice in Uganda? Does it mean a whole new mindset for lawyers and for litigants, too?
Oh, absolutely. It heralds a profound shift, no question. It suggests a future where legal practitioners are not solely defined as litigators, as courtroom warriors, but also as skilled facilitators of a resolution. Peacemakers, in a sense. For lawyers, it means really expanding their toolkit beyond just adversarial advocacy to include negotiation, mediation, arbitration skills. These become core competencies. It signifies a definite move towards a more accessible, probably more efficient, and certainly more user-centric justice system, where the emphasis is increasingly on finding durable, workable solutions rather than just, winning the case at all costs. This institutionalization, it points to a legal ecosystem in Uganda that is becoming more versatile, more responsive to the diverse needs of its populace, from those complex corporate disputes right down to local community conflicts.
And it must impact legal training, too.
Undoubtedly. It will influence legal education, encouraging, perhaps forcing law schools to integrate ADR much more deeply into their curricula. And it should foster the growth of specialized ADR firms. It's really about moving from a purely combative model towards one that actively seeks common ground and sustainable outcomes. That's a significant cultural shift for the legal profession.
That's a powerful vision of evolution. Okay, let's shift our focus slightly. We've talked about how ADR is growing. Now let's talk about what it can actually resolve. What kinds of disputes can ADR effectively tackle? Is it solely for those massive high-stakes financial cases we often hear about? Or does its reach extend much wider? Could it, for example, help resolve a disagreement between neighbors over, say, a shared boundary line?
That's an excellent question, and it gets right to a common misconception. Our source material is very clear on this. ADR's applicability is not solely restricted to financial matters or those grand corporate battles. Not at all. Its versatility is genuinely one of its greatest strengths. We see its utility across a really wide spectrum of civil matters. For instance, you mentioned construction. In the construction industry, disputes can be incredibly complex, right? Multiple parties, technical specifications, significant financial implications. ADR mechanisms like mediation or expert determination, even arbitration, are frequently employed here to keep projects moving, avoid those crippling delays.
Okay, so construction makes sense. What else?
Well, beyond the commercial spheres, ADR is profoundly impactful in sensitive family matters. Think about child custody and child maintenance disagreements. These are deeply emotional, often requiring ongoing cooperation between parents long after the dispute is settled. Mediation is particularly well suited here. The focus can shift from purely legalistic rights to the practical best interests of the child, allowing for more empathetic, more tailored solutions that traditional court battles, frankly, often struggle to achieve. You need flexibility there.
Right, the ongoing relationship is key.
Precisely. And furthermore, and this is a particularly insightful application mentioned in the Ugandan context, the concept of reconciliation, which is a cornerstone of ADR, is explicitly referenced for petty criminal offenses. Now, this moves beyond just civil and commercial disputes. It demonstrates a real commitment to restorative justice principles where appropriate. For minor infractions, rather than simply prosecuting through the courts, reconciliation can help the parties involved address the harm caused, make amends, maybe offer an apology, and rebuild community trust. Imagine, a local squabble over some minor property damage that escalates. Instead of dragging everyone through the criminal courts, a trained reconciliator can bring the parties together. They can discuss apologies, maybe restitution, figure out a path forward. That often yields a far more satisfying and community healing outcome.
So circling back to my earlier thought then, it could absolutely help with that family disagreement over inheritance, maybe, or that perennial neighborhood issue about a shared fence line or, I don't know, a constantly barking dog. It sounds like it transforms what could be a lengthy, draining, expensive legal battle into something more contained, potentially more amicable. A conversation focused on resolution, not just punishment or winning. That must be a huge relief for a lot of ordinary people who just want a practical solution that maybe preserves relationships, not a fight that destroys them completely. Okay, this brings us right to the core why. We've defined ADR, we've seen its growth in Uganda, we know its broad scope. But what are the truly compelling reasons for parties to actually opt for it? Why is it so important? What are its key advantages? Let's really delve into the specific benefits that make ADR such an attractive and increasingly preferred option.
Yes, this is really where ADR's value proposition becomes crystal clear. It directly addresses many of the pain points inherent in traditional justice systems. Our source outlines 7 pretty significant advantages, and together they paint a really comprehensive picture of its utility. First, let's talk about efficiency and quickness. This is a major concern, isn't it, in many legal systems globally, and Uganda is certainly no exception. Courts often face a massive backlog of cases. It stems from a large number of suits being filed, relatively few courtrooms, limited judicial resources, maybe insufficient funding. All this creates significant delays. It undermines that fundamental principle that justice delayed is justice denied.
It's frustrating for everyone involved.
Absolutely. ADR offers a powerful antidote here. It saves time. And as we all know, time is money, especially in business. For legal practitioners, too, the early and efficient disposal of cases through ADR allows for a more predictable income stream, better management of their overall caseload. It acts as a crucial supplement to court litigation, helping to clear that immense pileup of cases. And moreover, thinking back to those petty criminal offenses we mentioned, mediation and reconciliation processes can even contribute directly to the decongestion of prisons, offering swifter, often more appropriate resolutions for minor infractions than incarceration.
Okay, speed and efficiency. What's next?
Second, confidentiality. This is a paramount advantage, particularly in commercial disputes or sensitive personal matters. From the very outset, the ADR process is designed to be confidential. Unlike public court proceedings where details can become fodder for public scrutiny, media reports, gossip, ADR allows parties to discuss and resolve their issues privately. This is invaluable for individuals or businesses who are keen to protect their reputation, maintain privacy, or safeguard, say, proprietary information and trade secrets.
Right, like a tech company in a patent dispute. They wouldn't want their secrets out.
Exactly. Resolving that through confidential arbitration keeps the details of their innovation out of the public domain. That's a crucial competitive advantage.
Makes sense. Number 3. Third, ADR fosters informed decision-making. The process itself, particularly mediation, encourages a robust and often quite free exchange of information between the parties. Unlike the carefully controlled, sometimes strategically withheld information in an adversarial court setting, ADR focuses on uncovering and understanding each party's underlying interests, not just their stated legal positions. What do they really need? There's a built-in flexibility to share new information as the process unfolds, which allows for a more comprehensive understanding of the entire dispute. The neutral facilitator, the mediator, the arbiter, guides this exchange, but critically does not dictate the outcome, especially in mediation. This empowers the parties themselves to make well-informed, voluntary choices about their own resolution, leading generally to more sustainable agreements they actually buy into.
Okay, informed decisions. What else?
Fourth, ADR promotes a desire for resolution. Simply by engaging in ADR, parties inherently express at least some willingness to find common ground, even if it's just exploring the possibility. This in itself reduces the immense waste of time, emotional energy, and financial resources often expended in those prolonged, bitter court battles. In this setting, lawyers can pivot. They can shift from being purely adversarial advocates to becoming, well, peacemakers or problem solvers, guiding their clients towards mutually beneficial solutions rather than just a zero-sum, win-lose outcome. ADR helps parties, ideally, to set aside the often intense emotions that disputes generate, allowing them to focus on the practical or business aspects of the disagreement. The lingering emotional toll of an unresolved dispute can be devastating, and traditional litigation, by its very nature, can often prolong and even exacerbate these emotions. ADR seeks to short-circuit this, facilitating quicker emotional closure alongside the legal resolution.
Getting past the emotion to the substance, important. What's fifth?
Fifth, a really significant benefit is the immense creativity and flexibility in the ADR process. Parties can step away from the rigid formalities, sometimes the perceived chaos, of a courtroom. They can resolve disputes under the neutral, structured guidance of a mediator or arbitrator. This approach empowers parties to work collaboratively towards consensus, giving them considerable control over the process itself, from setting the agenda to choosing the venue. Unlike a court, where only legally relevant issues are typically heard, ADR provides ample room for discussing a much wider array of issues that extend beyond purely legal parameters.
Like what, for example?
Well, this could include things like formal apologies, which courts rarely order, or commitments to future cooperation between businesses, even developing broader, forward-looking business plans that would simply never be explored in a court judgment. This flexibility extends to the physical setting, too. Parties can arrange for convenient, comfortable facilities, fostering a less intimidating, more conducive environment for discussion. And that confidentiality we mentioned ensures parties feel safer to speak freely and voluntarily, encouraging open communication and, hopefully, creative problem-solving. Furthermore, ADR generally adheres less strictly to formal rules of evidence and procedure compared to court litigation. This can make the preparation significantly less burdensome, less technical, and more accessible for the parties.
Okay, flexibility and creativity, that's powerful. Number 6.
Sixth, it is generally less costly than litigation. This is often a major driver for choosing ADR. Traditional litigation, with its extensive discovery processes, expert witnesses, mounting court fees, potentially lengthy trials and appeals, it involves huge financial costs, often with very uncertain outcomes until the very end. Now, we must add a small caveat here. Highly complex international arbitration can, depending on the seat of arbitration, the lawyers involved, the complexity, it can sometimes be quite expensive itself.
Okay, good point.
But in most domestic contexts, and for many commercial disputes, ADR offers a significantly more budget-friendly route. The reduced time, the simpler procedures, avoiding those full trial costs, it translates into substantial savings for the parties.
Makes sense. And the last one.
And finally, number 7, a critical advantage in our increasingly globalized world. ADR promotes investment, particularly in international business. As international commerce expands, there's a growing need for a unified, predictable approach to settling cross-border disputes. The inherent differences in national legal systems can make traditional court-based solutions incredibly complex, very time-consuming, and potentially biased, or perceived as biased, against foreign entities. The existence of a robust, well-established system of ADR, especially international arbitration, actively promotes and attracts foreign investment. If Uganda wants to position itself as a key player in regional or international trade and investment, promoting and supporting international arbitration and mediation is crucial. This not only signals a commitment to predictable, fair dispute resolution, but also demonstrates the presence of robust resource persons, skilled arbitrators, mediators, lawyers, and the legal infrastructure capable of handling complex international commercial disputes efficiently and impartially.
Wow, that's a comprehensive and incredibly compelling list of advantages. It clearly illustrates how ADR empowers parties and offers a much more tailored approach to justice, moving away from that one-size-fits-all, often highly adversarial court model. It really seems to offer a path where resolution isn't just about who wins, but about finding the most beneficial, the most sustainable, and sometimes even the most relationship-preserving outcome for everyone involved. However, as you rightly pointed out earlier, no system is perfect. We need to look at both sides of the coin. What are some of the criticisms or potential drawbacks of ADR that our sources highlight? Are there downsides we need to be aware of?
It's absolutely essential to maintain a balanced perspective, yes. And the source material doesn't shy away from highlighting some inherent challenges and criticisms. It posits a very insightful criticism, actually. It has been said that the dilemmas that are faced by a judge are also faced by dispute resolvers.
Ah, interesting. What does that mean exactly?
Well, it's a crucial point because it challenges the perhaps simplistic notion that ADR magically removes all complexities. It suggests that while the process is different, less formal, more flexible, the fundamental human and ethical dilemmas involved in evaluating facts, considering fairness, weighing interests, and guiding parties towards a just outcome. These are merely transferred to the ADR practitioner rather than eliminated altogether.
So the hard questions don't just disappear.
Precisely. And building on this, the source explicitly states that the question of professional ethics and the need for the resolver to maintain a neutral stance still arise. This is a profound concern. While ADR is praised for its flexibility, this very flexibility can, if not carefully managed by a skilled and ethical practitioner, potentially open doors to new forms of challenges. For instance, think about a mediation where there's a significant power imbalance between the parties. Perhaps it's a large corporation versus a small local business, or maybe a financially strong spouse versus a more vulnerable one in a divorce mediation. The neutral's impartiality is severely put to the test here. They must ensure that the stronger party doesn't inadvertently or even overtly coerce or unduly influence the weaker party into an agreement, even if an agreement is technically reached on paper. The ethical responsibility to ensure a genuinely fair and voluntary agreement, rather than one born of pressure or desperation, remains absolutely paramount for the mediator.
That's a really important point about power dynamics.
It is. And furthermore, unlike court judgments, which set public precedents and are generally legally binding and enforceable through established court mechanisms, mediated agreements especially might face challenges in enforcement if one party later decides to renege or simply doesn't comply. Now, arbitration awards are generally binding and enforceable, much like court judgments under Uganda's Arbitration and Conciliation Act. But a mediated settlement often relies more heavily on the parties' good faith and commitment. Enforcement might require subsequent court action to turn it into a consent judgment if it's not automatically incorporated. Another criticism, particularly you might hear this from staunch legal purists, is whether ADR truly delivers justice in the same way a formal court ruling does, especially when complex legal points or broader societal principles are at stake. ADR often prioritizes settlement and compromise over establishing a clear legal precedent. And for certain types of disputes, establishing a legal principle through a public court case might be seen as a greater societal good, even if it's less efficient or more costly for the immediate parties involved.
That's a critical reframing, isn't it? It means that those human factors, the ethical considerations, the pursuit of genuine fairness and justice, they aren't removed from the equation in ADR. They're simply repositioned, perhaps even magnified, within a new professional context for the ADR practitioner. It really underscores that ADR isn't some kind of magic bullet that makes ethical dilemmas vanish. Instead, it demands a different, perhaps even more nuanced and challenging set of ethical responsibilities from its practitioners.
Exactly. And the implications of these criticisms, they just highlight the absolute importance of robust training programs, clear ethical guidelines, and rigorous selection processes for these neutral parties, the mediators, the arbitrators. For ADR to truly live up to its promise in Uganda, the individuals facilitating these resolutions must possess not only the technical expertise in the process, but also unwavering integrity, a deep understanding of power dynamics, cultural nuances, and an ability to genuinely maintain an unbiased, objective stance. Ensuring fairness and equity for all parties has to be the priority. Without this constant vigilance and commitment to ethical practice, the many benefits of ADR that we've discussed could, frankly, quickly erode.
Absolutely. Crucial points to keep in mind. Okay. With those important considerations noted, let's now turn our attention to the legal foundation of ADR in Uganda. It's one thing to have a great idea, a useful process, but it's another thing entirely to embed it firmly in law. How is ADR supported and indeed mandated by law? What's the legal backbone that gives it its authority and its growing prominence in Uganda?
The legal framework in Uganda provides a remarkably strong and significantly and increasingly mandatory foundation for ADR. This really underscores its institutional importance. It's not merely being presented as an optional extra anymore, it's being actively woven into the very fabric of the justice system. Let's begin with the general provisions. These are found right in the supreme law of the land, the Constitution of the Republic of Uganda, 1995, as amended. Specifically, Article 126, Subarticle 2, Clauses B, D, and E lay down some fundamental principles for how justice should be administered. These articles mandate, firstly, that justice shall not be delayed. That's a direct call for efficiency. Secondly, that reconciliation between parties shall be promoted a clear constitutional endorsement of a core ADR principle. And thirdly, and crucially, that substantive justice shall be delivered without undue regard to technicalities which, as we know, can often bog down traditional litigation. These constitutional directives create a powerful, overarching mandate for mechanisms like ADR that prioritize efficiency, reconciliation, and practical substantive justice over rigid proceduralism.
So it starts right at the top, in the Constitution itself.
Exactly. And building on these foundational constitutional principles, we then have the Civil Procedure Rules, SI 71-1. Order 12 of these rules is explicitly dedicated to scheduling conference and alternative dispute resolution. That tells you something right there. Rule 1, Sub-Rule 1 of Order 12 makes it very clear. The court shall hold a scheduling conference early in a civil case. Now, during this conference, the court's role isn't just to sort out points of agreement and disagreement between the parties. Critically, its role is to actively discuss the possibility of using mediation, arbitration, or any other form of ADR to resolve the case. And if, after this discussion, the parties don't reach an agreement themselves, but the court perceives a good potential for settlement through ADR, the court may then order alternative dispute resolution before a member of the bar or a bench named by the court. This is a significant institutional push, making ADR consideration a standard part of the case management process.
So the courts are actively steering cases towards ADR.
They are empowered and encouraged to do so, yes. Furthermore, Rule 2 of that same Order 12 stipulates that this court-ordered alternative dispute resolution shall be completed within a strict timeline, just 21 days from the date of the order. Now, this can be extended for a period not exceeding 15 days, but only upon application and for sufficient reasons shown. This clearly signals a strong legislative desire for swift resolution, directly combating those delays we discussed earlier. It's also worth noting that the Civil Procedure Amendment rules of 2019 likely further solidify and refine these procedural provisions, showing an ongoing commitment to strengthening ADR within the civil litigation framework.
Okay, so constitutional backing, procedural rules, what else?
Well, beyond these general provisions, Uganda also boasts specific legislation that provides the detailed operational framework for key ADR types. We have dedicated laws governing reconciliation, mediation, and arbitration and conciliation. Most notably, the Arbitration and Conciliation Act, Chapter 4 of the Laws of Uganda. These statutes provide the legal teeth, defining the processes, the roles of practitioners, and crucially, the enforceability of outcomes like arbitral awards. This gives parties confidence that the results of these alternative processes will be respected and upheld. And perhaps one of the most impactful developments, truly a game changer in recent years, is the introduction of mandatory mediation for civil suits. This is enshrined in the Judicature Mediation Rules of 2013. Rule 4, Sub-Rule 1 of these rules states quite unequivocally that the court shall refer every civil action for mediation before proceeding for trial.
Shall refer, so it's not optional.
It's exactly. For civil actions filed in the Ugandan courts covered by these rules, mediation is no longer just an option or a suggestion the court might make. It is a mandatory, non-negotiable step that must be taken before a case can proceed to a full trial. This dramatically changes the default pathway for litigants and lawyers alike. Mediation becomes the first port of call for settlement.
So what does this all mean? It sounds like Uganda hasn't just embraced ADR conceptually, but has established a really robust and, in many cases, mandatory legal framework to support it. This signifies that ADR isn't just some niche practice anymore. It's becoming an institutionalized, expected, and legally enforceable part of the justice system itself. This isn't just a gentle nudge from the system, it feels like a powerful legislative and policy push.
Precisely. And this strong legal and policy push serves multiple vital purposes. Firstly, yes, it aims to significantly decongest the courts, freeing up precious judicial resources for those more complex or precedent-setting cases that genuinely require a full trial. Secondly, it formally embeds ADR as a standard rather than an exceptional part of the legal process. This ensures that parties and practitioners alike become familiar with and utilize these valuable alternatives more routinely. And thirdly, by mandating it in many cases, the system actively promotes a culture of settlement and reconciliation, which directly aligns with that constitutional directive we mentioned earlier. It signals that the Ugandan legal system is proactively evolving to meet the demands of a modern society by providing multiple, effective, and legally sanctioned avenues for achieving justice.
That makes perfect sense. Okay, having explored that solid legal and policy framework, let's now dive deeper into the specific types of ADR mechanisms that are actively practiced in Uganda. What are the different flavors of ADR, if you like, that are available to parties seeking resolution? How do they differ in practice? What are the options?
Our sources clearly outline 5 key types of ADR practice commonly found in Uganda. Each has its own distinct characteristics, different levels of formality, and various applications, offering quite a diverse toolkit for dispute resolution. First, we have mediation. This is probably the most widely recognized and, especially now with the mandatory rules, frequently utilized form of ADR in Uganda. Mediation is defined as a flexible, confidential process where a neutral third person, the mediator, actively assists the parties in negotiating an agreement. The critical distinction here, the defining feature, is that the parties themselves retain ultimate control over both the decision whether to settle and the specific terms of that resolution. The mediator facilitates communication, helps clarify the issues, explores potential options, helps bridge gaps between the parties, but they do not impose a decision. And as we discussed, there are 2 main types: court annex mediation, which is integrated into the formal court process, and private mediation, where parties voluntarily engage a mediator outside of any court referral, perhaps for a commercial dispute or a family matter where they want maximum privacy.
Okay, mediation, party control, facilitated negotiation. What's next?
Second is arbitration. Now, this is generally a more formal and, crucially, a more determinative method of ADR compared to mediation. Here, the parties agree usually in a contract beforehand, or sometimes after a dispute arises to refer their dispute to an impartial third person, or sometimes a panel of persons known as an arbitrator or an arbitral tribunal. A defining feature of arbitration is that the parties agree in advance to be legally bound by the arbitrator's decision, which we call an award. This award is issued after a hearing process where both parties have had a full opportunity to present their case, their evidence, their arguments. So unlike mediation, the arbitrator makes a binding decision that is typically enforceable in courts, much like a court judgment, under the Arbitration and Conciliation Act. This makes it particularly attractive for commercial disputes, especially complex or international ones, where parties desire a final, binding, and enforceable decision without navigating multiple national court systems.
Right, so arbitration, third party decides, and it's binding. Got it. Number 3.
Third, there's negotiation. This is arguably the most fundamental, the most ubiquitous form of dispute resolution. It often happens long before any formal legal action is even contemplated. It's defined simply as a process of direct, back-and-forth communication between the parties who are in conflict. The primary goal is to reach an agreement or a settlement that addresses their real or perceived differences. Negotiation can happen directly between the parties themselves, just talking it out, or it can happen through their legal representatives. It's often the very first step in trying to resolve any disagreement, and it can actually occur at any stage of a dispute, even during a formal court process. People can still negotiate a settlement right up until a judgment is rendered.
The foundation of it all, really. Okay, 4th.
Fourth, we have reconciliation. This form of ADR, as we touched upon, is deeply embedded in the Ugandan legal framework, explicitly mandated by Article 126(2)d of the Constitution, which says reconciliation shall be promoted. It's defined essentially as the act of bringing 2 disputing parties into harmony, helping them find common ground when they might otherwise have been unable to settle their differences on their own. Reconciliation often extends beyond just sorting out the legal or financial terms. It focuses significantly on repairing damaged relationships, restoring goodwill, and mending the social fabric, particularly in communities. This makes it particularly relevant and effective in community disputes, certain family matters, and for those minor criminal offenses where the restoration of peace and social cohesion is paramount. It really emphasizes restorative justice principles.
Harmony and relationship repair. And the last one.
And finally, number 5 is conciliation. Now, this also involves an independent third party, the conciliator, who assists the parties in settling their differences, much like a mediator. However, there's a subtle but important distinction often drawn between conciliation and mediation. In conciliation, the conciliator can also give them an opinion on the dispute. They might evaluate the strengths and weaknesses of each side's case or suggest potential settlement terms. While mediators generally refrain from offering judgments on the merits or directing the outcome, a conciliator might offer an expert opinion or suggest possible solutions, drawing on their expertise in the subject matter. The parties are still ultimately free to accept or reject this opinion or suggestion, but the conciliator's input can be a valuable guide, particularly in technical or complex areas where an expert view is beneficial to move things forward.
That's a really clear breakdown of the spectrum, isn't it? From direct party-controlled negotiation at one end, all the way to the more determinative third-party decision in arbitration at the other, with mediation and conciliation offering those varying degrees of third-party guidance in between. Understanding these nuances, these different tools in the ADR toolkit seems absolutely crucial for anyone deciding which path to take for their specific problem. So for you, our listener, how do you actually decide if ADR is the right path for a dispute you might be involved in? It's clearly not a one-size-fits-all solution, as we've said. When should you lean towards ADR, and when might it genuinely be better to stick with the traditional courtroom route?
This is truly a critical evaluation point, and a good ADR practitioner or a good lawyer advising a client will guide them through this assessment honestly. It's about finding the right fit. Our source material provides some very helpful criteria for identifying both suitable and unsuitable cases, which is immensely practical for practitioners and parties alike to consider up front. Let's first look at cases that are generally suitable for ADR. Firstly, ADR is often ideal when both parties are genuinely committed to reaching a settlement. There has to be some willingness, even if it's tentative, and crucially, when time is of the essence. If speed, cost efficiency, and a desire for closure are high priorities, ADR almost always delivers significantly faster results than waiting for court dates.
Okay, willingness and speed.
Secondly, it's highly suitable when the parties desire or need to maintain a continuing relationship. Think business partners, long-term suppliers and customers, family members, neighbors. Litigation, by its nature, can irrevocably damage these relationships. ADR processes, particularly mediation, often aim to preserve or even mend these vital connections by focusing on mutual interests and future interactions.
Right, preserving the future.
Thirdly, it works best if the conflict is moderate and seems like it can realistically be resolved through the collaborative and communicative processes inherent in ADR. Disputes that are incredibly highly entrenched, may be deeply adversarial from the start, or involve fundamental disagreements on core legal principles might struggle to find resolution outside of court. Fourthly, cases tend to fare better in ADR, where there's relative equality in bargaining powers between the parties. If one party holds significantly more power, financial, informational, emotional, or quotient, there's a risk, as we discussed, that ADR could be used to pressure the weaker party. Skilled neutrals are trained to mitigate this, but it's a factor to consider. And finally, ADR is perfect for parties who actively want an informal, flexible process, and perhaps most importantly, for those who want to maintain control over that process and its ultimate outcome. They want to shape their own solution rather than have one imposed upon them by a judge.
Okay, so those are the green lights for ADR. What about the red flags? When is it maybe not the best route?
Equally important are the cases that are generally not suitable for ADR. Firstly, when a legal, commercial, or other kind of precedent needs to be set. ADR outcomes are typically private and confidential. They don't create binding legal precedent for future cases involving other parties. If a public ruling is needed to establish a point of law, clarify an industry standard, or perhaps create public accountability, litigation is usually necessary.
Setting a benchmark.
Exactly. Secondly, if the parties actively do not want a private or confidential setting, maybe they prefer a public forum. For instance, if public accountability, transparency, vindication, or achieving a kind of moral victory in the public eye is desired, the open court is the appropriate venue. Thirdly, in cases where a summary judgment is readily available from a court, this means a court can quickly and efficiently make a decision without needing a full trial because there are no significant material facts in dispute. In such instances, litigation can actually be faster and more efficient than even going through an ADR process.
Interesting. Sometimes court is faster.
Sometimes, yes, for those clear-cut cases. Fourthly, cases requiring injunctive and other forms of protective relief. These are urgent court orders needed to prevent imminent harm. Think restraining orders, orders to freeze assets, things like that. ADR typically isn't designed for such immediate, legally binding and protective interventions. These usually require the coercive power and authority of the court. Fifthly, and this is perhaps obvious but crucial, if the parties are simply not interested in settlement, or if one or both parties seem to be using ADR merely as a tactical maneuver to delay proceedings rather than genuinely trying to resolve the dispute. If the underlying intent is just to win at all costs rather than to find a resolution, ADR will likely fail and just waste time and money. Sixthly, if the offense legally does not qualify for ADR. As we mentioned, certain criminal offenses, particularly serious ones like felonies, cannot be reconciled or mediated. They require formal prosecution within the criminal justice system. And finally, if the parties definitively feel they need someone else with clear authority, like a judge, to make a definitive decision for them. Sometimes parties simply prefer an external decision-maker to resolve their impasse, rather than guiding them to their own agreement through mediation.
So what this all means, really, is that it's truly not a one-size-fits-all solution. Careful, honest evaluation is absolutely key to successful ADR. It's about ensuring that the chosen path aligns perfectly with the specific nature of the dispute and, importantly, with the party's ultimate objectives and needs. For that business partnership disagreement we talked about at the start, where preserving the relationship was key, ADR sounds like a perfect fit. But if it were, say, a complex fraud case needing a clear legal precedent set, perhaps litigation is the better route.
Exactly right. Understanding these parameters, these suitability factors, is crucial for practitioners advising clients and for parties themselves. It prevents wasting valuable time, emotional energy, and often significant financial resources on an ADR process that is fundamentally ill-suited for a particular dispute. A good lawyer or ADR professional will provide an honest, strategic assessment up front rather than blindly pushing for ADR in every single situation when it might not be the best fit. This careful evaluation ensures that ADR is applied where it can truly shine and deliver its promised benefits.
Definitely. Now, ADR, especially in mechanisms like mediation and conciliation, relies incredibly heavily on human interaction, doesn't it? And on the skillful guidance of the practitioner. It feels like it's not just about legal knowledge. It's profoundly about people skills, communication skills. What specific communication skills are absolutely essential for an ADR practitioner to be effective in navigating these often tense, often emotional human dynamics?
You've hit on one of the most critical aspects, absolutely. The effectiveness, the very success of any ADR process, particularly mediation, largely hinges on that human element. Specifically, the practitioner's ability to skillfully manage complex interpersonal dynamics. The source highlights several indispensable communication skills that really differentiate an effective ADR practitioner from someone just going through the motions. First and foremost is the ability to reframe questions. This is a subtle but powerful technique. It involves taking a statement, which can often be accusatory, maybe emotional, or very positional, they never listen, and turning it into an open-ended question that encourages deeper exploration and shifts the focus.
Can you give an example?
Sure. So if a party says they consistently breach the contract by delaying payments, a reframed question from the mediator might be something like, help me understand, what specific challenges did those payment delays create for your operations? And looking forward, what would a timely payment schedule ideally look like for you? See how it shifts from accusation to exploring impact and future needs. This technique encourages ongoing discussion, helps identify the underlying issues and interests rather than just the stated positions, and it's a powerful tool for generating a constructive agenda for resolution.
That's clever. Moving from blame to needs.
Exactly. And closely related is the general ability to consistently ask good open questions. These are questions that simply cannot be answered with a yes or no. They compel parties to elaborate, to provide more information, more context, more insight into their perspective, their interests, their needs, their feelings. Questions like, how did that situation impact you personally? Or what are your primary concerns if this issue remains unresolved? These are crucial for uncovering the full picture. Then, there's an often underestimated but very powerful skill, making effective use of silence. In a high-stakes, maybe emotionally charged discussion, silence can feel uncomfortable, awkward even. But a skilled ADR practitioner knows how to use it strategically. It creates space for reflection. It encourages parties to perhaps fill the void with their own thoughts and feelings, maybe thoughts they hadn't articulated yet. It can prompt deeper consideration without the person feeling pressured by another question immediately. Holding that space, precisely, and active listening is paramount. This goes far, far beyond just hearing the words being spoken. It means truly understanding the message, both the explicit content and the implicit subtext, including the underlying emotions, values, and concerns being expressed, maybe non-verbally. It involves giving your full, undivided attention, often summarizing or reflecting back what you've heard. So if I understand correctly, you're feeling frustrated because you felt your contribution wasn't acknowledged. And seeking clarification. Could you tell me a bit more about that? To ensure complete comprehension. The effective use of body language is also vital. Nonverbal communication is huge. Maintaining appropriate eye contact, which needs to be culturally sensitive, of course, adopting a neutral and open posture, not crossing arms, leaning in slightly, using the right tone of voice. These are all crucial nonverbal cues. They help build trust, encourage persuasion, and maintain a calm, professional atmosphere even when emotions might be running high. An interesting skill mentioned in the source is expunging, which is essentially about letting people talk to get emotions off their chest, sometimes called venting.
Letting them vent.
Yes, within limits. This venting process can be incredibly cathartic and is often a necessary precursor before parties can shift from emotional reactivity towards more rational problem solving. The practitioner needs to allow this space for emotional release, perhaps validating the feelings. I can see this is very upsetting for you, while simultaneously ensuring it doesn't devolve into unproductive conflict, personal attacks, or just endless complaining. It's a delicate balance of empathy and firm process control. The practitioner also needs that crucial balance of being impartial but firmly in control of the process. The practitioner must be adaptable, ready to explore new avenues as they emerge, pivot to different topics if one gets blocked, or introduce alternative options for consideration as the discussion evolves and new information or understanding comes to light. Ultimately, the ADR practitioner is a facilitator. Their core role is to keep the discussion moving forward productively, to ensure it doesn't just drop to a halt or go in circles. They need to use a diverse repertoire of communication techniques to encourage exploration, mutual understanding, negotiation, and ultimately agreement.
What's truly fascinating here, listening to that list, is how these skills, while absolutely essential for effective ADR, are also just fundamental for effective communication and conflict resolution in everyday life, aren't they? Whether you're navigating a professional disagreement at work or a personal one with family or friends, they translate directly into being a more effective communicator and, well, a peacemaker overall in any context. It truly highlights that the best ADR practitioners aren't just legal experts. They have to be masters of human interaction and communication. Okay, now that we have a really good sense of the critical skills involved, let's try to walk through the actual process. For someone encountering an ADR session for the very first time, maybe they've been referred to mediation by the court, what are the typical phases one might experience? How does a session generally unfold?
Visualizing the process can be incredibly helpful for demystifying ADR, yes. And our source material provides a clear diagram outlining the typical phases of an ADR session, often focusing on mediation as a common example. But it's crucial to understand up front, as you hinted before, that while we talk about distinct phases, it's not always a strictly rigid, linear progression from step 1 to step 5. In practice, it's often much more iterative, much more fluid. Parties and the facilitator might move back and forth between stages as new information emerges, as emotional shifts occur, or as creative ideas spark further exploration. So the first phase is generally preparation. This involves all the initial steps taken before the actual face-to-face or maybe online session begins. For the parties involved, this means gathering all the relevant information, documents, evidence they think they need. It also involves thinking hard about their own core interests and priorities. What do they really need out of this, which might be different from their initial demands or positions? And setting some realistic goals for the session. What would a good outcome look like? For the ADR practitioner, preparation involves thoroughly understanding the nature of the dispute. Perhaps by reviewing preliminary statements or court documents, identify the key issues likely to arise, and handling all the logistical arrangements, setting the date, time, venue, or online platform, ensuring it's a neutral and conducive environment for discussion.
Getting ready. Makes sense. What happens when they actually meet?
Right, next comes the opening phase. This is where all the parties, often with their legal counsel if they have them, come together for the first time in the session itself. The practitioner's role here is absolutely crucial in setting the stage. They need to establish rapport with everyone involved, make introductions, clearly outline the process that will be followed during the session, explain their own neutral role, emphasizing they don't take sides or make decisions in mediation, stress the importance and scope of confidentiality, and most importantly, establish clear ground rules for communication and conduct. How will they interact respectfully? This opening statement sets a respectful, constructive tone for the whole session and helps manage everyone's expectations, making sure everyone feels safe, heard, and understands how things will proceed.
Setting the ground rules. Okay.
Yeah.
Then what?
Following the opening is usually the most extensive and often the most crucial phase. Exploration information exchange. Some call it understanding the issues. This is where each party is given ample opportunity to articulate their perspective on the dispute, share their understanding of the facts, express the emotions involved for them, and critically communicate their underlying interests, needs, and concerns. What's really driving their position. The practitioner actively listens during this phase, asks those open-ended and reframing questions we talked about, maybe summarizes key points to check understanding, and helps the parties dig beneath their initial, often entrenched positions to uncover what truly matters to them. The goal here is achieving mutual understanding, not necessarily reaching agreement at this stage. It's about seeing the problem from all sides. And as we said, this phase is often highly cyclical. Parties might revisit parts of their story, need to clarify points, react to what the other side said. New facts might emerge. Someone might have an aha moment about their own needs or the other party's perspective, or new emotional insights might come to light that need to be acknowledged and addressed before moving on.
So lots of talking and listening, getting everything out on the table.
Exactly. And from that exploration, once there's a better shared understanding, the session typically progresses into bargaining, deal-making, or negotiation. Here, having hopefully gained a deeper understanding of each other's interests and priorities, the parties begin to generate, propose, and evaluate potential solutions to the problems identified. They engage in negotiation, exploring various options, making offers and counter-offers, considering potential compromises. The mediator helps them brainstorm options, reality test proposals, how would that actually work in practice, and facilitates the negotiation process. This phase is also often iterative, not strictly linear. A proposed solution might, for example, highlight a previously unarticulated interest or concern, which might necessitate going back briefly to the information exchange phase to fully understand its implications before refining the offer or exploring other options. This dynamic back and forth between exploring issues and negotiating solutions is very natural and often necessary in complex disputes.
Finding the common ground, testing solutions, and then, hopefully,
Yes, we reach the final phase. Concluding settlement. This is where any agreement reached is formalized. The terms of the agreement need to be clearly articulated, usually written down in detail, and commitments from both sides need to be secured. The goal is to ensure the agreement is comprehensive, specific, clear, unambiguous, and actionable, leaving as little room as possible for future misunderstandings or disagreements about what was agreed. Depending on the type of ADR and the context, this could involve drafting a formal memorandum of understanding, signing a legally binding settlement agreement, which might later be filed with the court as a consent judgment, or, in arbitration, the issuing of the final arbitral award by the arbitrator. And even this concluding phase can sometimes lead back to earlier stages. If, during the process of drafting the final agreement, complex details emerge or disagreements arise about the specific wording, it might require further discussion, clarification, or even a bit more negotiation to iron out those final points before everything is signed off.
it's truly interesting how dynamic and fluid that sounds. It's clearly not always that rigid, linear progression: prep, open, explore, bargain, conclude, but rather a flexible, adaptive back and forth, much more like real human negotiation actually happens. It really reflects the complex, often nonlinear, messy reality of human conflict itself.
Absolutely. And this raises an important question for the practitioners, doesn't it? How does the facilitator, the mediator, the conciliator effectively manage these transitions between phases? How do they keep things moving forward productively, ensure progress is being made without imposing their own solutions or rushing the parties? It requires a really delicate touch, active leadership of the process, not the content, and constant attention to the parties' readiness, both emotionally and intellectually, to move from one stage to the next. But the beauty of this iterative nature, this ability to loop back, is that it allows for organic discovery and adaptation throughout the process. Ultimately, this often leads to a more robust, more tailored, and more mutually owned resolution, an agreement that parties are genuinely more likely to adhere to in the long run because they had a real hand in shaping it themselves.
That makes a huge difference. Okay, before we wrap up, I definitely want to briefly touch on a forward-looking aspect that was mentioned as a point for discussion in our source material. It mentions the impact of COVID-19 promoting online ADR. Now, while the source maybe doesn't provide extensive detail on this point itself, it feels like a profoundly pertinent consideration for how legal practice, and ADR specifically, continues to evolve, especially in recent years.
It's incredibly insightful inclusion, yes, even just as a discussion prompt, because the logical connection is just so clear and so relevant now. The COVID-19 pandemic undoubtedly acted as a massive, unforeseen accelerator for the adoption and serious consideration of online methods for dispute resolution. not just in Uganda, but across almost every sector globally. And ADR, with its inherent flexibility and its generally less formal nature compared to traditional court litigation, was particularly well suited for this rapid, almost overnight pivot to online platforms.
It was forced innovation, in a way.
It really was. During lockdowns, travel restrictions, concerns about physical gatherings, online ADR wasn't just a convenient option. For many, it became a practical necessity to keep disputes moving towards resolution. This swift shift involved leveraging readily available technologies. Video conferencing platforms like Zoom or Teams became the virtual meeting rooms for mediations and even arbitration hearings. Digital document sharing platforms facilitated the secure exchange of evidence, submissions, settlement agreements. Secure online portals were sometimes used to manage case administration. This enforced push towards online modalities really demonstrated ADR's adaptability and resilience in the face of unprecedented global challenges. It proved it could work remotely.
Here's where it gets really interesting, I think. How these major global events, seemingly unconnected to specific legal frameworks at first glance, can rapidly reshape traditional practices. They can push innovative solutions like online ADR to the forefront, perhaps much faster than they would have evolved otherwise under normal circumstances. It's really a testament to the inherent adaptability of these alternative approaches compared to more rigid systems.
Precisely. And the potential for online ADR, or ODR as it's often called, is immense, especially for a country like Uganda that's looking to enhance its legal infrastructure, improve access to justice, and attract international investment. Firstly, it significantly enhances accessibility. It breaks down geographical barriers almost completely. Parties no longer need to travel long distances or even cross international borders to participate in a mediation or arbitration session. This is particularly impactful for those complex international commercial disputes involving parties from different continents, but also hugely beneficial for domestic disputes spanning remote or underserved regions within Uganda itself.
Makes justice more reachable.
Exactly. Secondly, this dramatically increases efficiency by reducing travel time, accommodation costs, venue hire costs, and all those logistical complexities associated with in-person meetings. This aligns perfectly with ADR's core advantage of quickness and cost-effectiveness. And critically, for Uganda's ambition to perhaps become a regional hub for dispute resolution, online ADR vastly expands the international reach of its ADR services. Online platforms allow skilled Ugandan practitioners, mediators, arbitrators to facilitate disputes for parties located literally anywhere in the world. This can significantly bolster the country's reputation as having robust resource persons and a modern, accessible dispute resolution environment. Now, of course, this rapid shift also brings challenges that need careful management. Ensuring secure and reliable online platforms, addressing potential digital literacy disparities among users, maintaining the integrity, confidentiality, and perceived fairness of online proceedings compared to face-to-face interaction. But the transformative potential to enhance access, efficiency, and reach seems to far outweigh these hurdles, provided they are addressed thoughtfully. It essentially builds directly on all those advantages of efficiency, cost-effectiveness, and flexibility we discussed earlier, pushing them into a new digital frontier.
What an incredible, really comprehensive deep dive we've had today. We started this journey by defining alternative dispute resolution ADR as this powerful set of non-court-based solutions, things like mediation and arbitration, designed for resolving conflicts within the Ugandan legal practice. We emphasized that fundamental point about the litigant's ultimate choice in how their dispute is handled. We then thoroughly explored its evolving landscape in Uganda, noting how, despite that long history of court-based adjudication being the default, the country has made truly significant, deliberate strides in integrating ADR. We saw the judiciary actively promoting it, court-annexed mediation becoming integral, and crucial local initiatives like ICAMIC and the older Cater flourishing to serve diverse needs, both domestic and international. We saw the incredibly wide net of disputes that ADR can actually resolve, from those complex construction disagreements and highly sensitive child custody matters, right through to potentially using restorative reconciliation for petty criminal offenses. Crucially, we spent time unpacking the compelling advantages of ADR in rich detail. Its efficiency and quickness, especially vital in a system often facing backlogs. Its paramount confidentiality, protecting reputations and privacy. Its ability to foster truly informed decision-making by focusing on interest. How it promotes a genuine desire for resolution and preserves relationships. Its incredible creativity and flexibility in process, allowing for tailored solutions. Its general cost-effectiveness compared to traditional litigation. And its vital role in promoting international investment by offering predictable and efficient dispute resolution. But we also critically examined its potential criticisms and ethical dilemmas, acknowledging that human factors, power imbalances, and the need for practitioner impartiality remain absolutely central concerns. We then dove into Uganda's robust legal foundation for ADR, highlighting constitutional mandates in Article 126, detailed civil procedure rules, specific laws like the Arbitration and Conciliation Act, and game-changing developments like the Judicature Mediation Rules 2013, which makes mediation a mandatory first step for many civil suits. We clearly differentiated between the various types of ADR available: mediation, arbitration, negotiation, reconciliation, and conciliation, and provided a very practical framework for evaluating when a case is truly suitable for ADR, and just as importantly, when it's probably not the best fit. Finally, we looked at those absolutely essential communication skills: active listening, reframing, using silence, managing emotions that make an ADR practitioner effective, and walked through the typical, often iterative phases of an ADR session before considering the transformative potential of online ADR, accelerated by recent global events, pushing dispute resolution into a digitally connected future.
And just to reiterate that key point, ADR in Uganda is clearly no longer just an alternative in the margins. It is rapidly becoming an essential, institutionalized tool for delivering justice and resolving conflict effectively, both locally within Uganda and on the international stage. It offers a powerful pathway that can provide more tailored, more cost-effective, and often more relationship-preserving outcomes than traditional litigation often allows. It's fundamentally shaping a more accessible, more efficient, and definitely a more forward-looking legal future for the nation.
Absolutely. And as we close this deep dive, here's a final thought for you, our listener, to perhaps carry forward and mull over. What stands out most to you about this whole idea of resolving disputes outside the traditional courtroom setting? And maybe more practically, how might the principles and especially those crucial communication skills we discussed today from ADR, things like active listening, reframing issues, seeking underlying interests instead of just positions, how might those skills apply to conflicts you encounter in your own life or work, even those far removed from any formal legal matters? Think about how consciously using those peacemaking skills could fundamentally change your own interactions and the outcomes you achieve. Thank you so much for joining us on this deep dive into ADR in Uganda. Until next time, keep exploring, keep questioning, and keep learning.